Just again, my name is Sarah Esterson, and my role at the Oregon Department of Energy is the Senior Policy Advisor. I don't know if that means too much, but I'll tell you a little bit about what I do in just a second. I've been at the Department of Energy for 6 years, and I primarily work with our senior analysts. Those analysts are the ones that receive applications for energy facilities and coordinate with state and local agencies in that review and basically prepare the environmental impact assessment and recommendations to our version of FSEC, and I'll refer to them as the council so we don't get confused. So I work very closely with them, and then I play a fairly large role in our compliance program as well as rulemaking. So I'm exhausted, if you can imagine. Okay, go ahead and move to the next slide, please. All right, so for this agenda item, my intent was to present information about the federal and state permitting process that has occurred for a proposed 300-mile, 500 kV transmission line, which I'm sure you've heard of it. It is the Boardman to Hemmingway transmission line. And that's a project that would start in Idaho and traverse 5 counties in Oregon to terminate in Boardman, Oregon, which is in eastern Oregon. And this project is proposed by Idaho Power Corporation in partnership with Bonneville Power Administration and PacifiCorp. Next slide, please. So I'm going to start with a brief overview of the project and its location, and then we'll highlight the overarching purpose and need, and then we'll talk about the federal and state permitting steps and status. So let's see. Okay, I think we talked about that. You can go to the next slide, please. So this shows you a close-up of some of the segments where alternative and proposed routes, where they are proposed. So on the left-hand side, this is just a, it shows you in the red line a proposed route, and then on the other side of the road is an alternative route that's in Morrow County. And then on the right hand side, you'll see we've got proposed route and rebuild locations in Baker County and similar in Malheur County. And that's kind of just to show some of the complexities. The project overall includes not just the 500 kV transmission line, it includes alternative routes, 230 kV rebuilds, switching station, communication stations, temporary multi-use areas that would cover up to 30 acres, temporary disturbance from pulling and tensioning sites, over 200 miles of new roads, over 200 miles of substantial improvements to existing roads. Next slide, please. Okay, and this is kind of similar, again, just kind of showing the extent of we're reviewing a proposed route and an alternative. The alternatives are fairly close to the proposed, but nonetheless an alternative that we evaluate and distinctively. Next slide. Okay, so the purpose of this project is to relieve transmission constraints, provide more opportunity for energy exchange, ensure the Idaho Power Company can meet its forecasted customer demand, and improve system reliability for future expected growth. Next slide. As we've talked about, the project has to receive both federal and state approval and has quite a complicated nexus of federal and state and local requirements that it's had to go through. So we'll start with the federal requirements. So because this project is proposed on federal lands and based on the scope of the impacts, review under the National Environmental Policy Act was required. And the Bureau of Land Management was the lead agency. They were responsible for developing and issuing the environmental impact assessment, which was issued in 2016, and then the record of decision was issued in 2019. And then additional federal steps beyond the NEPA process that were required were a right-of-way approvals and executed memorandum of understanding through Section 106 with Bureau of Land Management, Special use authorizations were required for impacts or access on Forest Service and Bureau of Reclamation land. Right-of-way approval was required from Department of Defense. Consultation with U.S. Fish and Wildlife Service was required for Endangered Species Act. And then removal fill Section 404 Clean Water Act approval from Army Corps was also required. And then on the next slide, I believe we have a status summary. This graphic was obtained from a website that Idaho Power maintains, just to give them credit. So you'll see up on the top bar the time frame of when things started for some of these federal approvals in July of 2008. And then you can see almost all of those federal permits and approvals that I just walked you through have been complete, except for the use authorization from Bureau of Reclamation and then the Section 404 Clean Water Act. So I think this is where, because we have Doug Young, you know, Doug, if you're interested in providing any input on the experience that you've had at the federal level with ESA or otherwise.
I think I'm on. Can folks hear me?
Yes.
Hi, everybody. Hi, Doug Young. I'm the Regional Energy Program Manager, Forest Service. We cover Oregon, Washington, out of the Portland office. I previously worked with U.S. Fish and Wildlife Service and at times was lead for my agency out of the Oregon State Office for endangered species, sage grouse, and other issues with Boardman to Hemmingway transmission line project. Now with the Forest Service, I was involved with the NEPA analysis that Bureau of Land Management was lead on. There were 4 federal agencies involved, and BLM was anointed the lead for that process, and we all relied on that final environmental impact statement for our own final documentation. So in our case, we signed a final record of decision, which provided Idaho Power instructions on what our expectations were for various subsequent stages of the process leading up to some sort of notice to proceed. But we started in the early 2000 or mid 2000s, late 2000, 2005, 2010 period, I think, working with Idaho Power. And we finally issued our easement in 2019. So it's a process that took a long time, had other agencies in the lead, had challenges. I don't know if I heard this real specifically in the presentation that just happened. There was alignment challenges between, I believe, the federal NEPA process, endangered species process, and the state process. And some of that, and I'll just be really brief in these reflections with Boardman to Hemmingway, some of these challenges were based on really early agreements and assumptions that these teams that Idaho Power set up and the frameworks for analysis and agreement on how we would categorize impacts and then do compensatory mitigation to fix those by resource areas didn't play through for that decade or so it took to get to the final analysis and licensing pieces. We had changes nationally in leadership, and that changed different things that affected those assumptions. And we always had a tension, in my mind, between the state process and the federal process. What should precede the other? They kind of proceeded in parallel, but it seemed like one or the other really should precede the other, so then you could mimic it with the second process. Endangered Species Act, I guess my observation is this was a challenging project, not necessarily for endangered species, but a species that could be listed under the Endangered Species Act, and that was sage grouse. And it was one of multiple projects throughout Western United States where Bureau of Land Management and U.S. Fish and Wildlife Service were trying to create similar frameworks for analysis and mitigation. And those didn't, once again, line up with the experience and intent of the applicant, and didn't necessarily perfectly align with the state of Oregon's compensatory mitigation policy. And so there was challenges within that aspect of citing, agreeing upon impacts, and then talking about how we might mitigate our way through all of that. That was my quick observations on B2H. Thanks.
Thank you so much, Doug. And you said, have you been, how long have you been involved in this project, in the regulatory review?
Originally with Fish and Wildlife Service back in around 2010 or so, when the project got started, all the way through when the Forest Service issued its easement, and still now as we're working with Idaho Power on the Forest Service compensatory mitigation package, and ultimately review of the plan of development and other documents necessary for them to receive the Forest Service's notice to proceed. Great.
Well, I hope we can connect outside of this presentation as well to talk about lessons learned. And so thank you so much for helping with this. Okay, so next slide, please. Now we'll move into the permitting requirements at the state level in Oregon. So for this project, a permit is required from the Energy Facility Siting Council, and again, I'll refer to it as council, which is the governing body of the Oregon Department of Energy Siting Division, the division that I work for. And a permit from the council is required because there's a statutory threshold for transmission lines that would then trigger a state level permit. And those triggers are about the voltage of the transmission line, the length, and whether it would be located in or cross more than one city or county. And so, of course, this project is greater than the 230 kV, which is one of the triggers. It's more than 10 miles, and it's located crosses 5 counties. So it triggers all 3 and is then state jurisdictional. And our process, which I think seems similar to the SEPA process, is intended to be a consolidated one-stop permitting process. And that incorporates all of the local land use requirements. It also it's intended to incorporate all applicable state statutes, rules, ordinances that would apply to the construction, operation, and or retirement of the facility. Next slide, please. Okay, this is where, so we just jump to the next slide. I move things around and then we'll come back to that. So I wanted just to point out, under the Oregon state permitting process, there's 16 standards that Idaho Power is obligated to demonstrate compliance with through the permitting process. Our process is referred to as an evidentiary process. So they would have had to provide facts and evidence to support their analysis of whether they believe they can meet these 16 standards or requirements. And then there's numerous other state agencies and rules that get state agency rules and statutes that get pulled in. Some examples are a noise control regulation that's under the Department of Environmental Quality. There's removal fill law under Department of State Lands, and those all get folded in to the Oregon state permitting process. So for this project, there were 2 other state agency permits that were incorporated, and that was the Department of Fish and Wildlife's fish passage law, and then Department of State Land removal fill. So it's effectively 3 permits in one, and then a compliance evaluation of, a number, at least 5 counties and probably 5 or 6 state agencies. All those requirements are part of the process. And let's see, so, and our process, we have a statutory obligation to coordinate with state and local governments to identify what all those requirements are. And then we, have a process for making sure an applicant then evaluates those in their application. So just a couple points on the council. The council is a 7-member governor appointed board. And again, we report and make recommendations to that body for whether to approve or deny a project based on evidence that's been evaluated to decide whether this applicant can satisfy all the applicable requirements. Okay, next slide. Okay, so this is just a quick graphic of our process. It's a 7-step process for Boardman to Hemmingway. They are at the contested case process. That's the red chevron, which is our version of a lawsuit. And once the project goes over to this contested case lawsuit, it's where issues are being contested. It does get handed over to a third-party attorney. And so it's out of our hands while we're a party to this lawsuit. It is an independent body that's making the decision on whether these issues can be resolved or whether they're so severe, this third party recommends the project should be denied. We are almost through that process. It's expected to conclude around the summer. And then we have just one more step after that, which is then we take it all to council for their ultimate decision. And then I do apologize if you want to go back to that slide with the schedule. It's just 2 slides up. Oh, right there. Yeah. So this is an overall schedule of the federal and state permit process. So if we go over to 2022, you'll see, and again, this is from Idaho Power's webpage, but they're forecasting final decision through the state process this summer, which I think that's on point. And then it shows, you can see here that the federal process notice to proceed is expected in early 2023. And I think that concludes the set of information I was intending to present. So I'm happy to answer any questions if you have any.
That was great, Sarah. Thank you so much for that. And Doug, for your comments as well. I'm looking to see, we do have a few minutes for questions. Again, inviting people to hop onto the mural board. And if you have any insights or observations, we'd love to have you note those. It will be in that lower half. I think it's yellow on the yellow colored little sticky notes. But honestly, if you put it anywhere, we'll get it to the right space. Are there any questions for Doug or for Sarah about Boardman to Hemmingway? Looking for hands and also looking in the chat. I don't think I've seen any questions raised in the chat. People might just be so overwhelmed with the amount of detail there in that project, and not in your presentation, but it's a complex project. Clint, I see your hand.
Yeah, I was just going to say thanks for taking charge on this project and helping to get it complete. It's 20 years in the making. It's scary that it takes that long, and I appreciate the challenges that the team ended up doing and accomplishing, not only taking on federal, but then also state and multiple county issues. So what we've been talking about here is complexities generally within states, but this is definitely one of the extremes and a great example of the challenges that transmission projects face. So thank you.
Thanks, Clint.
Susan, could I follow up with that?
Yeah, absolutely.
That really resonates with me and reminds me, digging up some Wayback Machine here, it was a long process. A lot of these linear energy projects take long time to work. I've worked through my career with Fish and Wildlife Service and Forest Service now on probably 15 or so multi-billion-dollar mega projects, these linear projects that might be interstate or intrastate. And what I've seen work best is those that work, they are not speculative. They're ones that you can tell from the get-go that they are players and they're going to get it built, and they move fast and they're really organized, and they put a lot of emphasis on staffing up and encouraging the team that works on these to staff up with the most experienced people possible and just carve out time and commit those folks for years and years and years, because it takes a long time and you want those experienced, risk-taking, I guess, what are some other adjectives here? Folks that are newer in their careers and they're going to be trained with cookie cutter approaches probably aren't the ones you really want on these kind of big, important, nationally recognized transmission line or pipeline projects. So the challenge is to move fast enough that you retain those folks throughout the process. So that is really challenging. There's so much turnover when you talk about a B2H type project with 15 years later. What were we agreeing to in our mitigation framework in 2010? That makes no sense when I'm the person now writing the special use authorization for the Forest Service. And so they don't match up. You gotta move fast. You gotta have the really creative, experienced folks working on them for a long period of time. Thank you.
Thanks, Doug. Appreciate that and that kind of lesson learned there. We do have a question in the chat about whether or not BLM is always the lead agency, but before maybe speaking to that, Sarah, do you have anything you wanted to add to Clint's comments?
Only that I, completely agree with Doug. I mean, that is the biggest takeaway from my perspective as well. And he's clearly been involved with the project longer than I have. But you have to have the right resources. And it's just a real challenge at the state government level to make sure that happens, because staff retention is difficult. So I don't know how we can solve that problem, but I think it's good to acknowledge the key contributing factor.
Thank you, Sarah. Does anyone want to take that question of, so Joe had asked, is BLM always the lead agency if there are other federal agencies affected? Allison responded to that from the Section 106 perspective. So just wondering if there is anything else, either Sarah or Doug, briefly about whether BLM is always the lead on these. And then we had one other question in here that looks like it might have been answered, but if you could speak to the BLM one as the lead.
I put something in the chat box, Susan, and I think,
oh, I see it.
I think what I just typed in there, which I asked my legal counsel to provide some input on this. So this is kind of mimicking what she gave me, that Forest Service is authorized to issue right-of-ways on Forest Service lands. This is a bit different than when there are multiple federal agencies and it's a pipeline project. And then I think Mineral Leasing Act takes primacy and BLM then has the right-of-way responsibility. And I'm getting those a little bit confused in my mind. But I think for B2H, the reason BLM was lead is they had the primary length of line on there with little snippets of Forest Service, Department of Defense, etc. That we just relied on BLM's process and expertise to be our lead for the other.
Got it. Thank you, Doug. There isn't one other question here, and then I think we'll probably go ahead and wrap this up and head to a break. But there was a question about
Susan. This is Allison. Can I just add on to that answer and just
Sure.
say, for lead agency, and as I said this in my answer, the federal agencies have to agree to who's the lead agency. So you will see sometimes federal agencies saying, nope, I'm going to do my own process. I don't want to have you as the lead. Same thing when you have two state historic preservation offices. We can agree to have a lead SHPO, so to speak, but a lot of times you have to consult with both of us. TIPOs can do the same thing. Tribal preservation offices can designate a lead TIPO, but sometimes they don't want to do that for various reasons. So it's not I guess where I'm going, it's not an automatic decision.
Got it. Thank
Susan,
you. Yeah.
Also, I wanted to just jump in here and ask for our BPA, is BPA always the lead agency on the federal side? So in our state, if we were looking at a project on the BPA system, how would that work?
Anyone want to take that?
Well, can I ask a question? When you say lead agency, do you mean for the project or for the environmental review process? Because it might be BPA's project, but let's say, so BPA has to go through 106, but then you need a core permit. So now the core has to go through section 106 and NEPA and everything else. So the question of who's the lead agency, I think, needs to be clarified as to what are you actually asking?
So
Okay.
perhaps Anders, if you can help us out here.
Anything to add, Anders? There might be another issue with muting and unmuting. So Lauren, I don't know if you can give a hand to Anders to see.
Let me
if we
see. Yeah, let me see. How about now, Anders?
Hello?
Yes.
Okay. Yeah, my understanding is that on transmission projects in the past where it was a BPA project where we were the owner and the project sponsor and the one building it, we were generally the lead agency for NEPA, and then there were other cooperating agencies as appropriate. And I think on projects where we, where someone else was the lead, we may have been a cooperating agency in the past.
Thanks, Anders. Kathleen, did that answer your question?
It did, but it is a really good question. I think if we can somehow figure out how to get information, maybe we'll hear this as well from our utility partners, because they would be the ones who might work in that nexus outside of BPA too, what they found. And I know we have some more time tomorrow for them to talk as well.
Great. Yes, we do indeed. Thank you, Kathleen, and everyone for that. I just want to mention briefly, Joel posted here in the chat wondering about if there was a proactive outreach campaign to get awareness or solicit feedback. Do any of you, Sarah, Doug, can you speak at all to the public process for this?
I'm sorry, is that question in the chat? I
It
just want to make
is.
sure I
It is in the
understand.
chat. Yep. And it's above the power line answer from Doug. So take a look at that, and maybe if you have something that you can speak to, it asks if the formal comment periods, if they were the primary mechanism, or if there was a proactive outreach campaign.
Yeah, at least for the state level, it would have been like procedural requirements during public comment period that we would have had to notice. And I would say in order to try and like increase participation opportunities, all comment periods were, like 3 times what would be normal. And half of that was upon request from people trying to participate, but we started with a bigger time frame and then gave more upon request. And then, I do think that Idaho Power did other things that weren't required through the state process, but I won't speak to that.